Buenas tardes, good afternoon, everyone. We're going to start right now. We're going to hold this panel in English, because most of the audience is English speakers, as we see, and we all are Spanish speakers this panel. Almost everyone from Latin America. We have 3 Colombians, and we are going to talk about this panel about international investment arbitration and constitutional law in Latin America. For this panel, we're going to have a judge from the Constitutional Court in my right, Alejandro Linares. Alejandro Linares is a lawyer from Andes University, and he has a master law in Harvard and a PhD in Externado University. In my left is María Paula Arena, that is a lawyer too from Andes University, and she is the director of, she's the chief negotiator of trade of investment agreement for Colombia. So she has experience for more than 20 years or so negotiating free trade agreements in the services sector, but also in the investment chapters in free trade agreements. And she negotiated just recently a BIP that we signed with Venezuela, which very different from all what we have signed before, and maybe that was that it was going to this issue is going to be addressed by Maria Paula by a recent decision from the Constitutional Court taken by Alejandro Linares and the other justices from the Colombian Constitutional Court. We have Nicolás Cobo as well from Chile. He is a professor of international, public international law in the Catholic University of Chile. He is a lawyer as well. He has a master in trade and finance in the Barcelona University, and he is the director of the Centro de Estudios Internacionales of the Pontifical Universidad Católica de Chile. We will have also with us to Ana María Ordóñez. She is coming from a meeting that she had with the General Controller of our country. She had to this unexpected meeting, and if she doesn't arrive on time, then her colleague from National Agency of Defense of Colombia that has the task to being the General Counsel of Colombia in human rights and investment disputes. So with this, we will talk about the constitutional limits of from the set by Constitutional Court in Colombia by decision C-251, which will be addressed by I will call you professor because you left the professor. Alejandro. I forgot that you're just sometimes, sorry. Alejandro. Yeah, Alejandro. And how that changed the fair and equitable treatment understanding of the negotiators. That for one part. So, and also, so, and then we will go with Maria Paula that will tell us about how that decision was taken by the government and by the past government and the current government, if they have different views, maybe. And Nicolás Cobo will talk to us about all the constitutional changes or the proposals that are being taking place in Chile, where constitutional changes include changing the way they see trade agreements, but also investment agreements. And then we will see how we go. 12 minutes each one. We have some presentations here. So, Judge Alejandro, the floor is yours.
Okay, thank you very much. I'm going to stand up is to feel like a professor. I'm not a professor. I'm not an academic person. I'm just a practitioner. Could you please put the PowerPoint? I'm going to talk about 4 points. First point, it's why we choose this subject. Second point, a little history of Latin America. The third point, the issues, the constitutional issues that I see in investment state dispute settlement. And the fourth is the future, how I see the future of investment state dispute settlement. I'm going to refer to ISDS.
Sorry, the blue one. Oh, the blue one.
I believe.
No, this is from yeah.
I have problem. So the first point, why we choose this subject. José Manuel was my director of my PhD dissertation at Externado. But I was the one who proposed the panel, and I invited several people, mostly from Colombia. I wanted to do like a diverse panel between men and women. But the importance of the subject is that there is new literature, there is a new research agenda in the world, not in the region, but in the world. It's a book by Stefan Schill on international investment protection and constitutional law. And when I say constitutional law, I refer to domestic constitutional law. And there is also this book, which is extraordinary, by Victor Ferreres Comela. The title is The Constitution of Arbitration, and he analyzes the constitutional issues of arbitration, not only commercial arbitration, investment arbitration, and also state-to-state arbitration. So to me, this subject is so important. And besides that, that's the book by Schill. But what happened with this panel is that I had a lot of work, and I was the moderator. I was the one who submitted the application for this panel, and Jose Manuel, he works more than me, he decided to take over the moderation of the panel, and he converted me in a panelist. That's it. The first point on why we choose this panel and why Jose Manuel is the moderator and I'm being a panelist. The panelist has to work less than a moderator. First point. Second point is history. To me, history goes in cycles, and in the history of Latin America is the great Andrés Bello, Carlos Calvo, the new international economic order of the 60s. Then the Node Tokyo was a 1964 rejection of the exit convention in Tokyo when they were negotiating the draft. Then the creation of ECLAC. ECLAC is the Economic Commission for Latin America. Then came ANCOM Decision 24 of 1970, which was the paradigm of the CEPAL, the ECLAC, the Economic Commission for America Latina. And now our continent, our subcontinent, including Brazil, which is not part of our continent, but Brazil also, we elected presidents with leftist ideology. Some of them populist, some of them not, but Chile is an example, Guatemala is another example, Venezuela, Colombia, we have a great president, Mr. Petro, then Lula in Brazil. So the region is coming back to some populism. So these doctrines have, the main points of these doctrines is you have to apply local law in disputes exclusively. Second, you have to submit to domestic courts. Third, you have to, in the contracts that you sign with the government, you have to waive your right to diplomatic protection unless there is denial of justice and you have exhausted local remedies. Now, there's a lot of literature saying why an investor is going to waive a right that belongs to the state. That's a different story, but we have still that provision in certain contracts, particularly oil contracts with the government have that provision. And finally, we have been, oh, sorry. We have been very suspicious always of arbitration, but this is not new. This is part of our culture, our legal tradition is that we are very suspicious of arbitration and we rely a lot on judges. I'm a judge, and that's why I decided to reinvent myself going to the judicial system. But that's history. Now and this history is, go please to the second one, is summarized, an excellent article by Alvarez Santos. I don't know if you have seen it, from Carola. This graphic is taken from, the reference is there, International Investment Law in the Shadow of Populism. And this is a summary of our ideology in terms of legal culture in the region. This is part of our history, and I have this chart here just to summarize our thinking in terms of applicable law, in terms of treatment of foreigners, in terms of dispute settlement, and basically we were and we will become very nationalist as to their investment disputes. So far for the past, let's go to the present. What are the issues that I see between a constitution and an international investment treaty, particularly international state dispute settlement? Issue number one, equality, equal treatment between nationals and foreigners. And there have been some very good arguments, some of them made to the court by José Manuel, saying investor-state dispute settlement discriminates, it's a reverse discrimination because local investors do not have access to international arbitration tribunals. That's issue number one, equality, which is a big issue in constitutional matters. Victor Ferreres has a whole chapter on equality, and it's really interesting. Second issue that has been, I have read this issue in the last version of Sornaraja book on the law on foreign investment. In his last publication, the fifth edition, I believe, Sornaraja says, by the way, investor-state dispute settlement is going to be challenged internationally because it could be considered as a block transfer of the judicial system to a private arbitration tribunal. And that argument could be renamed as the argument of parallel justice, privatization of justice in investment disputes, removal of investment disputes from the domestic courts, you name it. I mean, you could put different names, but the argument is the same. You are transferring to private arbitrators most or all of the investment disputes. So that's an argument that in court could fly, has not fly so far, but if things change in the world, it is going to start to fly in constitutional courts. The last issue is the reciprocity, which is the most favored nation clause violates reciprocity because it extends benefits to parties that didn't negotiate the treaty. It's a very interesting argument. It has been used by the court. It was used by the court in decision C-252 of 19 that has been translated into English by Externado and Rosario. It's available. I think it's really available. And that decision uses that argument. So there are at least three arguments, constitutional arguments: equality, judicial power, and reciprocity that could help arguments of unconstitutionality to win in the future. last point is we have new treaties, but unfortunately we have old outcomes. And the case in point is Ecuador. Here is Professor Gunes, who has written an article, a recent article published yesterday, I believe, on Ecuador. But there is a book by Professor Alsner from I don't know. Professor Alsner says old outcomes, new treaties, old outcomes, and refers as well to Ecuador, in which there was an exception to environmental matters, which even though the exception applied, still the tribunal said that there was liability, which to me, in my lawyer part of my head doesn't work the argument, but that's what the tribunal said. So my point is, if we start to lose, we haven't lost one case in Colombia. I mean, we lost Ecuador, but the damages award has not come out. If the damages award is not too big, then the issue would be manageable. But if the damages award in Ecuador is too big, then the courts, we are human beings, we read papers, and then we're going to start saying why this dispute, in which two decisions of the Constitutional Court are being challenged, why in the world it generated damages to the state. So I think that the international investment claims against the Republic of Colombia, because of decisions of the Constitutional Court, might change the view of the justices in the review of the next international investment agreements that are going to be posed to the court. Fortunately, I will not be at the court at that time, but it's a risk. Has been that those arguments have been made. José Manuel, René Urueña, Enrique Prieto, they have made those arguments, and those arguments have not fly, but they could fly in the future if the political context changes in Colombia. My last point is the future. I don't know how is time. 1 minute? Yeah. Okay. Last point. What do we do for the future? My view, this is not originally mine, of course, is what Gabriel Kaufman-Koller and Podesta proposed in an article published in 2020, saying there has to be an allocation of roles between domestic courts and international courts and international arbitrary tribunals. The key, and they use this word, fruitful work division. And how do you work that? You work that with limiting the jurisdiction of the tribunals. Certain issues should not go to international arbitration. For example, environmental matters should not go to international arbitration. Human rights matters should not go to international arbitration. And then the exhaustion of local remedies for certain disputes should be, I mean, there should be exhaustion of local remedies for certain types of disputes, so that you would only review the final judicial decisions, the domestic judicial decisions, in extreme cases of denial of justice. So there has to be an egregious conduct of the judicial system, so that you will have an international claim before an international investment tribunal. I didn't have the time, sorry, to talk about the recalibration of the substantive standards, which is embedded in judgment C-252 of 19. But I thank you, José Manuel, for the panel.
Thank you so much for that. And okay, but now we will see with Paula what the outcomes of the decision and how are felt and feel in your work as negotiator of these agreements. Okay, so you go ahead.
So first of all, I would like to thank José Manuel, Universidad del Rosario, Universidad Externado, and the Society of International Economic Law for this invitation, and of course, being sharing this panel with my colleagues is such an honor. So I wanted to talk about three subject matters. I would like to refer myself to three issues, which I think that from my experience and from my current job and my current post, I could talk about. And of course, I think that this is very important because it has to be with your question, what we do, what should we do? And of course, this is the conclusion and the results of what has been, what Colombia has been trying to do and facing in terms of not only dispute claims, but only in terms of investment negotiations. So the first point is that I would like to talk about what Colombia is facing and what we're trying to do in terms of negotiation policy, public policy. The second point is just what has happened in terms of the decision of the Constitutional Court on the agreements with Israel and France, how we dealt with it, how we faced it. And the third point would be, of course, our last subscribed agreement, which is the Colombian-Venezuela BIT. So in terms of, can we just start with the slides? Thank you very much. Okay, the first thing I would like to bring here is a little bit of history as well. And it is what happened 2 decades ago. 2 decades ago, as many countries in the world, let's say worldwide, Colombia decided to start negotiating and internationalized the country under the negotiations of agreements. Let's see, it means FTAs and international investment agreements. That was a decision because we thought that we could bring international and direct investment agreement because of those treaties. Among other public policies, those treaties could help to these goals. And maybe it helped. Maybe it was we had results, but maybe not. And we all know that now it is so debated and this is so discussed that things have changed. No, we now have to make changes, and this is why Colombia is making some changes in the, let's say, in the following and in the last, let's say 2 years. But I might say that right now, and with the new government, those changes are more than clear. And this is why I'm bringing this. In Colombia, we have 19 treaties into force. And of course, if you compare Colombia with the 6,000 existing treaties worldwide, it's not that much, but it is. And it really is, and that's what we're going to see right now. Next. Our partners. And of course, then what happens, and you know that we know that international investment agreements have been subject of very criticism, political, social, and academic levels of critics. We just received. So we now know that we have to make changes, and we are facing those criticisms, and we are trying to make changes just to really have reactions of this criticism. You see here that in terms of globally debates, you see that we have, regarding the scope of international investment agreements, we are reviewing the scope of the international investment standards. We have been talking about here the FET, fair and equitable treatment, but in the different fora, we have seen that not only FET is one of the main subject matters of debates, but also standards that we thought were basic, like MFN, are now subject of many criticism. And in Colombia, we are also reviewing these kind of standards. Exceptions, I think that you just mentioned what happened with the Cobo. we have an exception very clear in the FTA with Canada. We have an annex, and then we thought that it was enough. I mean, the negotiator there, I think he might be thinking that it was enough, but it was not. The court or the tribunal just decided that it was not enough, and that in terms of FET, the negotiators should have included explicitly how it was an exception. So if you try to carve out every exception in every treaty, you will never finish it. So this is something that, yes, we have to bear in mind. So sorry. And we are facing it. We are now trying to include as well the right to regulate clauses, to really have strong clauses, very strong clauses on human rights, and a subject that you might be thinking about, this is a question that we have to raise and we have to face, which is environmental clauses. We right now, and we have now, the Paris Agreement, which is a very important referent worldwide, and we are discussing it at the OECD, not only at the OECD, but also in UNCTAD. And Colombia, in Colombia, we are bringing those clauses, those debates, to build our new model BIT. And right now, this is what we are building and really doing within the ministry. Because we do think and we do feel that we have to include every concern, or almost any concern, and every mistake, let's say mistake, that we have walked on the past. We have to make something new in Colombia, to give responses. So that's what I wanted to tell you about what we are doing and how we are facing new negotiations. For instance, what we are going to do is reviewing the current investment agreements we have. So that means that we have to review the chapters included in the FTAs and the bilateral investment treaties. And you know that we have different changes to address them. Because of course, when we know that we have like a treaty into force until a time, we can review it and renegotiate it. This is the case we have right now with Switzerland, with China, with UK, and we had this same context with Spain, and it was easier because you just renegotiate the agreement, and this is something that we are doing right now. But when we face investment treaties within the FTAs, we have to address it differently, doing joint interpretations, as the ones we did with Israel and France. And which is the subject that I'm going to address right now.
4 minutes.
Okay, very generous. I will be very quick. I didn't want to leave without talking about the influence of the decision brought by the Constitutional Court, referring to the agreement with Israel and France. And I have to tell you what happened when we received this decision within the government. In this moment, we tried, and what we did was really to understand what it meant. And what it meant, what it meant. We had to open the negotiations with the other partners and renegotiate substantial matters, which were the standards. We know that in the case of France, it was FET, MFN, and national treatment. And in the case of Israel, it was national treatment and FET. So the first thing was to approach the partners and renegotiate them. But I have to say that it was very successful, and not only very successful, but it was a precedent. Because right now, what we are trying to include in our model BIT is as well what we had to do in these circumstances. So I think that it was a very good experience. It was very useful for us as negotiators, and that's it. And then the final subject I wanted to talk about is Venezuela. I mean, Venezuela is another, a very different model, BIT, we just negotiated. It only has two main investment standards, which are national treatment and expropriation. And that I think this is the most, let's say, the most important change that we had in terms of BIT. I think the time is running out.
No, we still have one.
Okay, that's it. No, that's the case of Venezuela. So I think that that your question would be like, is Venezuela going to be the model BIT for Colombia in the following negotiations? I think that this is like a reference, it's like a path. We are, of course, taking into account Venezuela, but we know that every partner is different. So we, of course, are trying to take into account Venezuela, but we are building this text with the other subjects that I just mentioned, with our clauses on environment. And I might say that Venezuela is not that rich in terms of environmental issues, but we are taking into account, of course, the Venezuelan text.
Thank you. Thank you so much, Paula. And just arrived on time. I want to introduce to you to María Ordóñez. María Ordóñez is the director of the International Defense of Colombia, or international claims in human rights and investment claims. She is a lawyer from the Pontifical Universidad from Colombia, and she has a master's in King's College, London. I just want to say a couple of things because I don't think they're completely clear on how the Colombian system works. Every treaty signed by Colombia needs to be reviewed by the Constitutional Court. And in that process, anyone can file amicus. And maybe this is a question that, or something that I expected to hear in this panel, to see what you were thinking, if you can say so, of course, in the court when the problem arrived, and what happened in the agency, and what happened with inside, because I know what the public things you were saying and in the hearing that we had before the Constitutional Court. And just to, so in that process, the Colombian branch, BIT, went to the court. And we find out, in our opinion, with a few colleagues here, with Enrique and with the Constitutional Law Department from Externado and myself, that, well, this treaty doesn't seem very much like the other. This one seems a little bit worse. And maybe some misspellings are in the fair and equitable treatment and other provisions on MNF. Okay, let's go together and file different submissions. And that's what we did. And we planned it, and we are happy with the decisions that you have taken in the court. I know you had a decent opinion. Maybe it's not as happy as the rest of the justices, but and that's how it works, our system. So maybe if we can talk about that later, it would be good. So Ana María, just welcome, and the floor is yours.
Thank you, José Manuel. Good afternoon, everyone. Thanks for being here. Thanks to the organizers, Linares, who was the creator of this panel. It is always an honor and a pleasure for me to talk about what we have done on regards of Colombia's international legal defense before investment tribunals. So we are, the title of our panel is Investment Arbitration and the Colombian Constitution. You can help me, thank you. And I think that lucky for Colombia, we arrived to the system in the middle of a backlash, and there was a lot of criticism because a lot of states had suffered what is seen as some injustice regarding investment arbitration. So Colombia is a country that, despite having signed several investment agreements, had not a single claim before exit or regarding investment arbitration until 2016. And Maria Paula can back me here. We were an example. UNCTAD used to invite every country to look into Colombia because they must be doing something very, very, very good because they have not a single investment arbitration against. But what happened? We were a phenomenon. We came from 0 to 10 in just 2 years. So we had to react very quickly. There was always the question on what is happening in Colombia. Is there a change in the political model? Is there a change in a particular sector? And nothing is happening in Colombia. Nothing. Just now we can tell everybody that what happened is that it's just a maturity. This is a dispute resolution mechanism, and it was taking its time to mature the dispute so that they could come to investment arbitration because nothing happened. But the way we organized, so we decided to implement Colombia's defense strategy in 2 fronts. We took very seriously to understand and to participate in the different multilateral scenarios where the criticisms were discussed. And we used that participation so that we could implement lessons learned and good practices from other states so that we could have an effective defense. We were very conscious that one of the main criticisms was that there was not enough deference before states' decisions. And also that in some cases, investment arbitration was used like as a paralegality from the domestic regime. So we decided to be very vocal and to be very conscious on the importance of creating these decisions, these defenses, in order to present to the investment tribunal the importance of respecting that and the rules. Those were the rules that they had to respect. Also, we were very vocal regarding independence and impartiality, the importance of arbitrators to be independent, impartial, and we were also very conscious that the regulatory chilling effect should not happen in Colombia. And that's how we built all these defenses. Can we change, please? Thank you. And that's how we used the Colombian Constitution. When we were preparing this panel, it was asked that they wanted for us to tell you how we have used the Colombian Constitution in our defenses. So we have worried to defend Colombia's institutional organization. And our institutional organization is based in the Colombian Constitution. So how do we use the Colombian Constitution? Is the base of each and every defense of Colombia in every investment arbitration. So what does this, what has been the result of this strategy? We have been successful because we have managed to prove our point. That was something that we also said in multilateral scenarios, which is that, again, I repeat, investment arbitration does not create a paralegality. Investment arbitration does not allow investors to abstract from the rules that are created in our country for everyone. Rules apply to each and every investor, domestic or foreign investor. So that's what we have. That's the base of our international defense. So we have defended regulatory powers. We have worried to explain how the Constitution Constitution is the base of each and every decision that has been questioned internationally. So that has allowed us to submit and to represent before tribunals that investors should have known that those measures could come. Why? Because a lot of those measures, and that's my next slide and the next point of my presentation, have been taken in order to respect the Constitution, to guarantee human rights, to guarantee the protection of the environment, which is not only a principle that is incorporated in our Constitution, but in international general principles. So we have managed to obtain certain degree of deference in investment arbitration, and we have protected state sovereignty, besides, of course, saving taxpayers a lot of money. So what's the result? So we have 3 examples, which are public, because we have also worried always for our defense and the decisions that deal with the Colombian interest to be public. So the first one is the case of Naturgy, and in that case, 2 interesting lines of analysis regarding the Constitution and Constitutional Court's decisions. The first one is that Spaniard investors always complained because they were not allowed to cut the energy service to some users that didn't pay but had a special constitutional protection. So they said that was the state allowing or promoting certain practice, which is not paying for the light, because in any case, it was not going to be cut. And what the tribunal interestingly said is that we don't see why they are complaining about this, because these decisions and these protections come from the Constitution, and the decisions are dated before they make the investment, so they should have known better. So with this load, we could say, or this responsibility that this tribunal put into the investor, we can see that there is some deference before states, because the rules of the game, the rules that Colombia has established, were respected. You cannot come to international investment arbitration to complain from something that was in place before you made the decision to make the investment. And the other interesting line is that the tribunal did understand that Colombia made the decision to intervene or take control of this electricity company that was fully owned by Spaniards for a legitimate purpose. They found that, in effect, the state is responsible to guarantee fundamental rights. And the provision of public utilities, and to 10 million people, which is the amount of population that that company had to serve, is perfectly reasonable. And the analysis, they said, we are not here to second guess if that decision was right or not. What we can see also is that those were the rules that were established. The company knew that they had the risk of the superintendency to intervene them if they failed to provide the service to 10 million people. So that's very interesting. Then there is the other case that we won. It's America Móvil. And regarding the Constitutional Court, that case, what that case does is that it leaves very clear that international arbitrators only come to review decisions that are made by domestic courts when there is a denial of justice. So investment arbitration, again, is not like a 4th instance or whichever instance we can call it, from decisions that are made internally, which investors are not happy about. That's not what international investment arbitration is for. It's an exceptional alternative dispute mechanism and should be used responsibly by investors. And the other decision that I know it was made reference in the presentation of Mr. Linares, it's the Ecuador decision. And yes, despite Colombia was found responsible for the fair and equitable treatment standard, but regarding expropriation, the tribunal did find that it was perfectly reasonable, objective, and adopted in good faith that Colombia had the intention to forbid mining in the Páramo, which is, I don't know what's the proper.
High wetlands.
It's not high wetland, it's moorland, the moorland, because it's ultra exceptional, and only Colombia is the country that has the most, and we need to protect them. So they said, I don't see any problem. You did not expropriate that investment. But they did find some things in FET, and I agree that it was a very good treaty, but not very good applied. The final decision has not been made yet, but what we want to highlight, and a good point of that award, if you could say, is that they did respect and they did recognize that in the Colombian Constitution, we have the duty, the state has the duty to protect the environment. That's a fundamental right from the population. And for Colombians that are here, it is also called the Green Constitution, actually. Our constitution is called the Green Constitution. So they did find that, and they did back Colombia's decision to protect the moorland. So those are our decisions that I invite you to consult, and are those decisions that allows us to conclude that those criticisms that were in place when Colombia started being an active defendant in investment arbitration have made an impact, because we can see that arbitrators recognize themselves as guardians of the system, and they have started to listen, at least in Colombian cases. I know it is not always the case, and anything can happen. We have 14 cases pending. Several are pending from decision, so we'll see. But so far, we are going good. Criticisms are paying. Those multilateral efforts are worth it. Even though we have not been very effective as a state on delivering products, but we can say Maria Paula and I have been very active in the UNCITRAL Group 3, and the Code of Conduct for Investment Arbitrators has just been issued, and it's now in place, and that's something that we think will contribute to improve the system and to have good decisions.
Many thanks, Ana Maria. We will go over them again with the questions, and now, last but not least, Nicolás Cobo, who will talk to us about the Chilean perspective and the three constitutions. I believe that countries normally have one constitution, but Nicolás wants to talk about the three constitutions from Chile, and in investment arbitration in the context of this constitutional change, and also the practice, or the practice that Chile thinks that it will work on the offside level.
Thank you very much. Thank you all, and thank you the organizers. Let me start with an apology. I need to talk something about more close to realismo mágico, because it's difficult to explain something that is difficult to understand. Three constitutions in one country in less than a year, not that easy. Second apology is I cannot guarantee the articles I will show you will be approved, because we have a referendum at the end of the year, and it's unclear if this decision will be taken. So we have moved to sort of consensus in the Chilean society from different governments in order to open the markets, to sign many agreements, FTAs, bilateral investment agreements, multilateral. So there was this consensus, and we have three constitutions. Why I mentioned three constitutions? We have the current valid constitution, which is 1980, that was amended already 70 times. The constitutions that was the draft proposed and rejected in last year, 2022, and the current draft. We have another draft that is to be discussed within 6 months and open for a referendum in December. So some history. So the history shows that from 1974, during the military government, there was a decision to reduce the tariff and to open the markets, bilateral FTAs open to the world, and the experience of the law decree 600, which is very important for investment. And then came the democratic government that continued that decision. So there was a lot of press and difficulties, but at least in this area, there was sort of consensus in the society. And then this consensus, I choose this date, 2019, because you probably are aware that this political struggle we have at the end of on October 2019, that was ended up in an agreement from the political parties in order to sign a new constitution, discuss a new constitution that was rejected for 63% of the population. And then we have another constituent process with different characteristics, and we will discuss a little on that. And what I will discuss a little, focus on what is allowed or banned by the current constitution related to FTAs and investment. So first, in this consensus, we have reached 31 investment agreements. We have signed 2 international investment agreements with Hong Kong and Uruguay, and 11 chapters of investment included in FTAs. So that is part of this consensus. Now, also, there was a consensus on the open of the trade. We have retail agreements with 85% of the GDP and the population. So, with a continuation, with several big governments to keep that decision. But this consensus finished in October 2019. Probably was developed the lack of this consensus before, but it slowed and it became very visible. And then there was this discussion of this constitution, ended up in a rejection, a large majority. And now we are living another experience with a draft already existed, drafted by 24 experts. And now they already show this draft to be discussed by 50 elected members for 6 months, and the final referendum at the end of the year. So, what about this constitution's draft and what is conditioned, rejected, or restricted, particularly about the dispute settlement agreement? So, the final draft rejected last year included a lot of influence from regional constitutions, Bolivia, Venezuela, Ecuador, that was somehow didn't match the sensibility of the Chilean population, so it was largely rejected. But they, in this draft of 2022, include a lot of bans and prohibitions and limitations for future governments in order to sign dispute mechanism under the ICSID. But now we have a new process. In this process, I can give you a general exception. So far, it maintains a similarity with the current constitution. The current constitution was amended 7 times, so it's not the Pinochet's constitution. but that constitution with several reforms. And with some innovation that will come closer. So here are articles proposed by the experts and to be discussed now for the 50 members, elected members. So it maintains the presidential approach that the president shall conduct the international relations, the negotiation of the treaties, and the approval of the Congress. And then the Congress maintains some faculties. They approve or reject, so it's a passive role. And the president will inform the Congress about the content of the scope of the treaty. So it's a similar situation of the current constitution. And the Congress may suggest formulation of reservation or interpretative declaration. This is also similar to the current constitution. The approval of the Congress shall be necessary when you want to withdraw, denounce, or terminate an existing agreement. So there is a new role in the Congress for the to abandon some of the existing treaties. The president will inform to the Congress about the agreements that include alternative solutions of controversies that may have been reached. This is not existing at the current constitution. So this is new and has some emphasis in the matter that we are looking for now. The final ruling in courts related to international human rights is also recognized in the current draft and should be fulfilled in accordance to the process expressed by law. This is not under the current constitution. This Article 6 is similar to the current constitution, a mention of the limitation of sovereignty related to human rights, and again acknowledge about the sentence on international court related to the international human rights, and related to concessions. This concession of exploration may be carried out by the government or through administrative concessions or special operating contracts. This shall be approved by a supreme decree. It is somehow similar to the current constitution. The explicit compensation, the president may terminate without expression of cost with the corresponding compensation. So the first conclusion is, at the moment, and with the uncertainty of the realismo mágico, the current draft maintains substantially the similar options and decisions on international strategy as it exists today, which is very different from the previous experience in 2022 that really want to add a political program within the constitution and limit future governments to change that. So the big difference from the current status from the previous one is preventing the government a foreign policy program. So in this draft, we are not limiting that. I have also come to another aspect, which is the side letters. Side letters, probably you know, but this government that does not agree with this consensus, and they don't want to sign the CPTPP that was already negotiated and approved by the Congress, so they found a loophole. Say, oh, we have to sign the treaty, but we don't like this treaty, so why we don't use the side letters in order to avoid, particularly the dispute settlement article. So what are side letters? A bilateral agreement between states that are parties to a treaty and seek to clarify, modify, or render ineffective some of the aspects of clauses of the said treaty. And the case that it comes to our attention here is Section B of Chapter 9 of the CBP, Investment State Dispute Resolution. So they want to withdraw that article by commitments, bilateral commitments of some of the existing members of the CBP. The model of the idea came from the New Zealand experience that actually did find some side letters. And so Chile says, oh, this is a very good idea, we can use this. But everything remains in force according to the FTA that both countries previously negotiate with the ASEAN, meaning that the model of the New Zealand does not avoid the use of other existing mechanisms, secure mechanisms, that are similar to the one that the government wants to exclude. So they also include the friendly solution. So there is a 6 months opportunity to discuss in a friendly way before to go to a formal dispute solution mechanism. So what said the Chilean government? So we have promises from many countries in order to sign this letter, and they raised this case. Canada and Australia in order to commit to reform, Mexico in order to suspend, Malaysia in order to suspend, and New Zealand in order to suspend. So all these countries want to sign letters with us, which ended up not entirely true. So what is the effectiveness of signing this? So you can withdraw this part of the article bilaterally. But there are some other existing treaties among the same parties. So you don't use that section, but you will use another mechanism which is very similar. So they would remain in force, regardless of this commitment, particular and bilateral commitment. And especially because there is a specific article in the CTBTPP of code system. So this agreement accept and understand there are other agreements, valid, bilateral, that are in full force and will be applicable in order to solve this problem. So from the members of the CPTPP, 10 members, there are 5 that already have bilateral agreements with Chile. So at least from these 5, you cannot change what is already signed in another agreement. So the existing dispute mechanism, investor-state dispute, will be full in application. So I'm finishing. The legal effect of that, are we better off to sign this agreement? It looks really useless because you try to avoid some commitment that is already a binding international obligation, but there are other existing obligations that ended up in a similar mechanism. So what about the arbitrator? Future arbitrations in a conflict will apply which standard? The CPTPP standard or the previous treaties standard? So that goes to a confusion and an uncertainty. And ambiguity is not a good sign for lawyers. Well, the second conclusion, and here I'm finishing, trying to circumvent, avoid some commitment, existing, valid, and binding commitment by signing bilateral agreements. It's not that simple. You have pacta sunt servanda, good faith, and other principles that are still applicable, even though you want to avoid something that you didn't negotiate, you didn't approve in a political. It's not part of your program, but it's already a valid and existing obligation. But lead us to an uncertainty on future interpretation. I believe that's it.
Okay, thank you. Thank you so much. So now we have more or less 22 minutes to, if you want to elaborate in my previous question, to know what, if you can, of course, and if you want to respond, what would you were thinking while in the court when the decision was taken? Can you talk about that, or is that is private? Or?
That is private, and no. I'm a very pragmatic person, but the original, the draft of the original opinion written by Professor Bernal declared the proposal to the court, to the plenary, was to declare unconstitutional certain provisions of the treaty, which means that Colombia had to renegotiate the whole agreement with France and then go to Congress and then go to the court again, because in our system, the court has automatic powers to review international treaties. And because of some amicus curiae of Enrique and José Manuel and René Urueña, most of the arguments have been accepted by the person who drafted the opinion. The discussion of the court was so interesting, and that opinion has a reserve of 5 years. So in 2024, I could write my article on what we did, but I anticipate what we did. And what I said is, in the discussion, if we want to be pragmatic, and we don't want the government at that time, President Duque, to go back and renegotiate the agreement. Also, Israel was there as well. And there was a lot of pressure to have the Israel treaty to be signed and to be approved by the court. What I said is, let's apply the Vienna Convention of the Law of Treaties, Article 31, and let's condition the constitutionality of the agreement to the agreement of the parties after the treaty was signed. So in practical terms, meant that by means of, let's quote it, a side letter or an interpretation of the agreement, then the treaty wouldn't have to go again to Congress and again to the Constitutional Court. That's basically what we did. The whole discussions, I'm going to write about them once the original opinion could be disclosed to the public. Okay. But that's basically what happened.
Oh, okay, thank you so much. And I think, well, in the next SIEL meeting, we probably will hear from that. Okay, so and from your point of view, but yes, because this is the side letters strategy that or whatever in Chile is happening to the side letters or the other interpretation of the treaty, which is more or less the same at the end of the day.
I think that was part of the discussions, and then we have another history of what happened next. But of course, it was very helpful, I would say, because it helped for us to, and I might say, to reopen the negotiation with Israel and with France. I mean, the first approach with them was like, okay, we have to talk. We now know that it's closed, the negotiations, but we have to talk and to do something, because otherwise the agreement wouldn't be entered into force. No, never. So it was, let's say, like the hard part, the hardest part was to one, talk to the other side. But I think that the joint interpretation was a good idea and a good instrument to do so. We hadn't have to change the entire text, and of course we just signed it, and we did what we have to do in those cases, which are, like, let's say, diplomatic exchange of notes, and it was very easy. It took some time, let's say like 6 months each for each, and what we did as well was that we were renegotiating the agreement with Spain. And we thought that it was better to make so with Spain, let's say, to make another joint interpretation before submit the agreement under the Congress and the Constitutional Court. So for us, and I say that those kind of instruments, it worked for us.
Okay, thank you so much for the generosity. And I guess for the agency and the defense of the states, you were happy that you didn't have to deal with 2 bits and potential claims from French investors. But above that, what else? What were you thinking, or how did you see this decision?
Well, I think it was actually a milestone internationally. You must know that several academics internationally always are quoting and looking into this constitutional court decision, which I think it was the Colombian institutional organization operating, and it was a very clever way, you could say, that allowed Colombia to transform first generation treaties that were not as good into second generation treaties. And so it's good if from the point of view of the agency, if we have better treaties, it is way much more easier to build effective decisions based on respecting Colombia's institutionality, state sovereignty, and all this. It is going to be very interesting to see how tribunals will interpret those notes, because that's another very interesting discussion that is going on among academics and states and practitioners, and what should be the value of these tools that investment agreements have, such as interpretative notes and also non-disputing party submissions, because they are not always taken into account by arbitrators as states wish for. So that will be a very interesting phase of this decision of the Constitutional Court. So far, we don't have any claim based on those treaties, but we'll see.
Okay, thank you.
Let me make a footnote.
Okay.
We review at the same time the BIT with France and the free trade agreement with Israel. And because we didn't have enough time, we applied the same standards of France to the Israel treaty, with one main difference. The Israel treaty, we applied only to the investment chapter, a very high standard of review, whereas to the trade provisions, which were bigger, we didn't do any review at all. So if you read the decision with Israel, it's a copy-paste of the French decision, but we didn't talk about the different chapters of the free trade agreement with Israel, like human rights, subsidies, government contracts. I mean, lots of issues, lots of things which are as important as the investment chapter. That's one of the flaws of the Israel decision.
Yeah, well, yeah, and I intervened in that too, and it was a human rights issue. Is that we were very surprised with because with the Palestinian franja. I don't know how to translate franja. And well, okay, this is I'm just the moderator, so let's say Nicolás, side letters and interpretations as you've seen the Colombian experience. What would you say about that, or could you elaborate on something for the Chilean experience, or give us some ideas or thoughts?
I would say back to basics, back to the principles. The convention, the rules of interpretation, and the principle of the treaty, which is good faith, pactos sunt servanda, stable contractor, and the respect of the main purpose and object of the contract of the treaty. So within this, you can sign a cycle in order to have a nuance, some particularities that you have with some of the partners. I don't see any problem with that. But here, I think the discussion was different. It was more on an ideological base. We want to avoid the application of a treaty that didn't actually agree, but it was already approved from the political sector. And there is another question, the limitations on the Constitution. So you need to let the discussion, the democratic discussion of the political force and the community, the social forces, about the future of the country. But when you want to limit everything, try to show fear of future majorities that the ones you are having now will not have a good future. So I think back to basics, good faith, and respect the main purpose of the object.
Thank you, Nicolás. Okay, now you have 11 minutes, 12 minutes for questions. Ricardo, Rodrigo, Enrique, and Gustavo. Go ahead.
Thank you. Well, I have a question for Nicolás.
Le pasas el micrófono.
The Nigerian government was more dogmatic decision rather than entering into the substance. No, I was wondering whether at the end, if you come to the TPP, than I know this for sure, that the Mexican-Chilean agreement, which by the way, you mentioned about the side letters, the free trade agreement between Mexico and Chile used to omit any food because Chilean will take the food. I'm surprised now they take this view about side letters. But looking at the substance, if you look at expropriation, if you look at measures, of course, why would the government not rather like saying, okay, well, even if it was a previous government, what was the agreement about more on the substance that rather dogmatic decision?
Thank you. I just wanted to ask to the panel, what even is the title of the panel? Is basically the connection between international investment arbitration and the connection, Latin American constitutions? It's a matter of. It seems to me that were a matter of principle, we should same attitude is that it seems to me from the given that actually what we are discussing, and so that's not very constitutional to me. Why we keep investor arbitration between Colombia and Venezuela? Yes, it's an expropriation, national agreement, but also in France is there, and we criticize the very basic ISDS that with other countries. So yeah, that's my question. I mean, for the rest of the world, what we are discussing now, it seems new. This criticism about the investor arbitration. For Latin America, it's old news. It's 1964. It's the Note of Tokyo again. We discussed this. We said it was against our constitutions. We didn't ratify these treaties. We didn't make it, and we did. And now, so my question is this a matter of principle or it's a matter of fact? You shouldn't give me the mic.
Thank you very much to this amazing panel. I have one question for Maria Paula and another for Ana Maria. Sorry, just jet lag. Maria Paula, it seems that it's very interesting how you told us about the possibility of revisiting and renegotiating old agreements. Now, it seems for the story told by Justice Linares that civil society and universities academy played a very important role in the decision, right? Like basically civil society and academic, academia, we made the government and the institutions think about the effects, negative effects of this. So, but now the government continues top down, right? So you're trying to renegotiate, you're thinking and not bringing civil society and universities that we were the first to ring the bell. Now, have you considered setting up a commission with universities and civil society and not only you guys? And now for Ana Maria, sorry. Ana Maria, as when you presented, you said that something very important for the agencies try to avoid the regulatory chilling effect. But it is happening. We have the Land Restitution Office that clearly stated in a document that they're not representing a group of victims because there was a risk of being sued by foreign investors on their bilateral investment treaty. So it's already here, it's documented. So how can you try to avoid that, something that is already happening? Those are my questions. Thank you.
Yes, thank you very much, and thanks to all the panelists. And it's always an honor to listen to my mentors and colleagues discussing these issues of international investment law. Sorry. Okay. So 2 questions. The first question is going to Maria Paula. We have seen a new trend, no, in international investment treaties, particularly in Africa and in Asia. So now investors are getting obligations, sustainable development provisions, social responsibility provisions. So which is your approach on that trend? And my second question is for the Ange. So I would like to hear your thoughts about the amicus curiae briefs, especially now that we had the case of Ecoro, that many NGOs tried to bring amicus curiae briefs, and it was not in the case of the Constitutional Court that they listened the amicus curiae briefs. And what is your approach regarding that? What we should do? We see also new trends that are trying to recognize the amicus curiae brief. And thank you.
Challenge and measure under the CPTPP, Chapter 28, reinvest provisions in Chapter 9, but six want to suspend Chapter 9. Side letters also suspend ISDS or CPTP state, retain the right under state DSM. In fact, the state DSM could be better for investors in certain circumstances, because even if there is no compensation, the remedy is bringing the measure into conformity with sovereign retaliation with BDR. Yeah, basically the land restitution office that they represent victims, right? For land restitution judges, we published an article documented in which the office rejected to take a case on the grounds that the current owner was a foreign investor and representing the victims, which is actually African Colombian communities, could make the Colombians responsible. So they suggest to take the case to the Colombian Commission of Justice, right? And that's what made they have the document with all the facts. Exactly, so they were very chill and effective. Informing public entities, because we think information is power. And if you know which are the rules, if you are fully aware how tribunals need to set investment registration, how investment provisions work, how tribunals decide them, how they analyze them. You as a civil servant responsible to make decisions and know how to do it in order to be able to have the international. Again,
we consider, and what's important is that this doesn't allow investors to abstract from the application of the law. That's something that each and every entity has to do. They need to do it. They just need to know that there are some international standards that should be respected, but whenever every tribunal analyzes those standards, the Colombian law, the rules, are used in order to determine whether there is a breach or not. So the position of the agency is first informed. We are informing. Second, to ascertain, to work together with all entities that are making those decisions and that are in risk. And from our experience, at least from the government, we can find that, and we never tell any entity to not do this because they do know better what to do. And again, that arbitration does not should not freeze entities on what they need to do. We just let them know which are the standards, and if we do something, we tell them how to do it. So in our experience, that's what we do. That's what we are doing, and the decisions that that we have defended back our position. We can give them peace of mind, public servants, with concrete examples. So that would be a very interesting example to see, because I get it. The mission of that entity is not even specific to give that answer. So they need to work with that, because that's not the, I mean, because we need to always watch Colombia's strategy, which is different. We always watch Colombia's defense strategy, but that doesn't mean that we go to entities and tell them don't do it. And regarding amicus, we are of course open. We are fully aware that what we defend is the public interest, and it's almost normal that it's natural, and we are open to receive and to open arbitration to amicus. The thing is that we also need to be mindful about cost, because investment arbitrations are very costly, and every paper that is submitted before the tribunal means more hours from the arbitrators especially. So that's why they are very mindful, and they are not open to accept interventions that are not directly related to that will open the debate to some issues that perhaps. So I think that the advice should be to find that proof, and to make sure that what the amicus is invoking actually is directly related to this. Otherwise,
In the case of a Cobo, was directly related with the standard of protection. Anyway.
I'm going to answer Rodrigo's question. There's that one? Yeah, only that one. Go ahead. I recommend to you two books. They're very good. Not related to law. One is written by a Colombian, Granel. It's called the Linares-Cantillo. Extraordinary book that shows why we are so ideological and not pragmatic. The other book is by another Colombian, Mauricio García Villegas, which is sad emotions in the country. And those two books reflect why Latin Americans and reflects why I started with history. Because we have nostalgia of history, and then we are very ideological. However, in the 90s, we had the Washington Consensus, and our presidents decided to open up the economy. And we were pragmatic enough to sign investment treaties. What is happening now is that the cycles are coming back. The left is winning in Latin America, and then our constitutions are leaving empty. Therefore, and that's why I my alert is perhaps one of our constitutional courts, perhaps the Colombian constitutional court, is going to stroke down ISDS even in the Venezuela case. Why? Because the winds are changing. And we may go back to the Calvo doctrine or to the Bello doctrine just because it's a reinterpretation of the same provisions of the Constitution that were enacted in 1991, but there is a twist there. So, for example, the equality clause in our Constitution, Article 13 and Article 100, could be reinterpreted, and we could say ISDS gives a privilege to foreign investors, therefore ISDS is unconstitutional. Or same with the most favored nation clause. The first most favored nation clause signed by Colombia was in 1824. There was a huge debate about that provision. So, in a nutshell, we Latin Americans are becoming again ideologic and less pragmatic. Those who are extraordinary.
Okay, thank you. There's two questions. One from Ricardo, thank you. I totally agree. It's a very dogmatic decision. And I totally agree also that it's more state-friendly. And I have only a guess. I can try a guess why they took and they took this path. First, I think it's the lack of technical advisors, and it's by looking the appointments of the government on the international area, not experts at all in but very few cases. And there is a question that I can raise to them. Why you have so many similarities in this aspect of the CCTV if you are a far left government with Trump, which is a far right government? Two of these parties were against the CCTV. There's no sense based on the political approach. Another question from Hugo. Thank you very much. I also agree. He asked whether they will suspend Chapter 9. No, they cannot unless they reach the treaty. The silence only apply to the withdrawal of the exit dispute mechanism, and not the rest of the treaty. So unless you want to breach the contract, you have to comply with the treaty and the general rules of international law, the Vienna Convention, and you cannot act against the main subject, and you have to follow the treaty, and you need to act always this way. And if you want to find an excuse from an interpretation really not very clear, you will breach it.
Okay, Enrique. So what you're raising is very interesting. So we have to think about how to provide what we are doing. In the moment we are trying to draft negotiations, and we're also prioritizing those agreements that we think that we have to negotiate or renegotiate earlier. It's something that we are doing. What we want. Direct obligations to investors. I think that's well very interesting and very important to know that the model, the African models are very great to point to those kinds of solutions. We have been looking after that, and we are trying to draft something which could work to us, Colombia, in order to really gain some goals with our partners. As well, we are, what that means is that we are trying to make stronger clauses on the protection of communities. And of course, in terms of environment, not only we are trying to make stronger clauses, but we are trying, or not trying, but our model will exclude some sectors of agrarian, like animals, forests, water, and that's a good example of what we are trying or looking to grow.
Very much. Questions were going to be answered, so I'm very happy today. So please join me in this.